welcome to the first edition of the Michigan Journal of International Law podcast. I'm Ryan Shaw, a current 3L and managing articles editor of the Journal. I'm thrilled to be here on a beautiful fall Saturday morning in Cleveland, Ohio, at the American Society of International Law mid-year meeting. So here at MJIL, we have the privilege to publish articles from a number of the scholars that are present at this year's conference, and among those is Professor Harlan Cohen, who joins me today. Professor Cohen, thank you for being with us and for being the inaugural guest on the podcast.
Thank you for the opportunity to talk about my ideas. I appreciate the opportunity to be in the journal. I mean, it's been always one of my favorite international law journals. It's probably some of the best work I know, but I appreciate also the opportunity to talk to everyone.
That's very kind. So to begin with a little bit of bio, Professor Cohen is currently at Fordham University Law School, and his teaching and research focus on international law, international trade, international legal theory, global governance, and U.S. foreign relations law. He is a vice president of the American Society of International Law and the recently elected co-editor-in-chief of the American Journal of International Law. Professor Cohen's latest article is International Law, the International Order, and the Definition of Security, which we have the privilege of publishing in MJIL. So Professor Cohen, just to start off, if you could give us a little bit of background on your areas of research and maybe just a little bit about how you became interested in international law going way back.
Oh, sure, yeah. I mean, like many, probably involved in your journal, probably thinking about international law, watching this, I probably started to be interested in high school. I did things like MJIL. In college, I did international history. I did a graduate degree in international history after that, also international studies. So, I mean, these were things that were kind of on my mind. One of the things that I studied when I was doing history work was the culture of diplomacy. I was looking at kind of the period at the beginning of the Cold War and the end of colonization, and trying to kind of see the ways in which diplomatic culture adapted, or more often failed to adapt to the new realities of the situation where states like the United Kingdom, the United States, were having to figure out new ways to talk to states they had once treated as kind of mere puppets, but now they were necessary allies. When I got to law school, I kind of thought that I was going to move on from international stuff, do something else. But what I quickly found taking international law classes was that international law was actually the language that I was looking for, that I've been missing, right? It was it was that culture of diplomacy. It provided kind of the way for diplomats around the world to actually speak to each other, the way for them to make claims on one another, the way for them to argue with one another. So I sort of became fascinated with that and wanted a chance to study that more.
Well, fantastic. And I think that culture of diplomacy that you talked about is interesting in the context of your article, which kind of analyzes the context by which diplomacy can be done in the international order. You describe the international order as kind of an interpretive mechanism in your article. So could you just talk a little bit about the relationship between the international order and international law, and kind of how your article kind of reconciles the two?
Yes, it's a really hard question, and I think it's a really important question right now. Right? So I think that many who are interested in international affairs right now are looking at the world and seeing that things are changing, perhaps in ways that might be concerning or disturbing, and they're trying to make sense of it. And one way people often make sense of those changes is to say, well, the international order is shifting. I say the international order is shifting. I'm not sure any of us know what that means, right? What does it mean for international law to say that the international order is shifting? Is it something operating on international law from the outside? Is it international law itself that is changing? Right? What's the relationship? And this is in many ways what I'm trying to kind of unpack in this piece, because I think it's important if we want to understand where international law is going and what's driving it in those directions, perhaps with the hope of then driving it somewhere else, we need to understand kind of what are the actual dynamics behind it. I think it's easy to say in a kind of descriptive sense that the international order, if we think of that as the particular configuration of power in the international system at any given time, and international law, if we think of that as kind of the rules, are mutually constituted, right? So The order is in many ways constituted by law, right? What power looks like is something that can only be understood against background legal rules. So sovereignty is a legal norm. The fact that states are the ones who get to speak and not others is structured by law. But in turn, power, right, the international order also structures law, right? So we should not be surprised that the legal rules are the ones that powerful states generally have favored, right? But that's not really satisfying in trying to make sense of where things are going. Okay, so we know it's mutually constituted, great. So what I try to work out in the paper is trying to think about a much more direct role that the order might be playing here. And what I come down to is that it seems like at least one aspect of the relationship between the international order and international law is that the international order is the actor, is the agent, is the mechanism for deciding which rules live and which rules die. It decides between interpretations, right? The sense is if we imagine kind of the court in the domestic system as the final decider of which legal meanings get to prevail and which ones will wither away, in the international system, it's the order that plays that role.
And you, in that analysis, rely pretty heavily on the work of Professor Robert Cover, who was talking about kind of the role of courts in being that what you call the jurisdictic agent. Could you talk about how you tried to kind of transpose Cover's work into the international legal context?
Sure. I'd first say that if anybody watching this has not read Robert Cover, they absolutely should. Right? Absolutely brilliant, mind-opening work. In particular, the piece that I rely on a lot here of Nomos narrative, one of the most interesting, thought-provoking pieces one could read. But what Cover was doing in that piece was he was really sort of trying to shift the way we think about courts and legal meaning. Right? So a lot of times the way, particularly in law school, we talk about courts, we think of courts as making meaning. Right? They're the ones who are deciding, so they're the ones in a sense in that creative role. But he basically wants to argue that no, it's quite the opposite, right? That in our daily interactions, right, in our legal communities, right, in some ways it's constituted with our legal communities, we make law, we make legal meaning, right? In arguing about what I expect from you and what you expect from me, right? We are interpreting the rules, right? And that is sort of the natural kind of birth of legal meaning, right? It comes from those relationships within the community. When the court comes in, the court's not playing a jurisgenerative role. It's not playing this creative role. It's playing a jurisdictic role. It's playing a role in killing meaning. And that role is necessary because if the community had no way of actually deciding whose meanings prevailed and whose meanings didn't, right, the community would just pull apart entirely. So you need kind of that institution making those decisions, but that institution isn't doing a creative act. It's doing a deadly act, right? It's wielding kind of an axe to kind of kill off various meanings. Now, when Cover was writing this, he was writing this as a way to promote pluralism. Right? He was saying courts need to be much more, be humbler, more modest, more responsible in thinking about the role they play, doing that because they really are killing off these meanings, right? That there's value in having kind of people in the community able to express their views about what the laws are, and courts should be somewhat more modest in playing that role. I kind of want to turn this on its head here, right? So I think what we see in international law, right, we see the jurisgenerative nature of the community, right? If you think just about custom as an example here, right? Custom is built on arguments about what the rules are, right? That is where the rules are coming from. They're coming from interaction, right? That's the lifeblood of the legal rules. What we don't have in international law, at least what we don't have a singular court, right, the U.S. Supreme Court, that could decide on meanings. Right? We have courts, but they all have limited jurisdiction. Right? They don't have the ability. They can wound, they can't kill. Right? So the question is, who is actually deciding meaning here? And I think that if we, again, going back to the idea with regard to courts in the domestic system, we need something to decide on meaning if we want to maintain some cohesion in the international community, right? We don't just want to be in separate silos around the world. So if we're going to have something that decides on meaning, what's doing that? And here, I basically argue that it's the international order that's playing that role. Right? The international order is the thing that is actually determining which meanings prevail and which ones die, and that is both a destructive force, but also a necessary force for maintaining some kind of community cohesion.
Right, and the case study that you use in the article is what you call the definition of security, but also it's about how states want to define economic coercion and what responses under international law they should be authorized to do should they be economically coerced in the same sense as were they to be physically coerced. So talk a little bit about how the state's interpretations of the definition of security and of economic coercion have changed, specifically when it comes to developed states who you argue are now adopting an interpretation that looks a lot like how developing states were conceptualizing it, and what this says about how the international order kind of is that juris pathé.
Yeah, so I think these questions about the definition of security and coercion are very, very live right now. They're a really good example of how this process plays out, right? So going back to the post-World War II era, right? I think you could go back before this, but I think given the changes in international law created by the war and by the UN Charter, it makes sense to kind of start there. We can see debates then about whether or not economic coercion is prohibited under international law and what it would mean to prohibit economic coercion under international law. So in that period, right, you've got, say, the UN Charter codifying a prohibition on the threat or use of force against the territorial integrity or political sovereignty or political independence of any particular state. That leads to debate as to what that should mean. What kind of force is prohibited? And you have a whole group of new states, right, coming into the system who very much want that definition to include economic coercion. Right? To them, right, seeing the way the world has developed to that point, the thing that is most threatening to them is the economic power of the former imperial or former colonial countries. Right? So they want that definition in there. They fight over it with regard to the UN Charter. They don't get it explicitly in there. That fight continues into the 60s. So you then again see this during debates over the Vienna Convention on Law of Treaties, where they have to figure out if coerced treaties are going to be invalid, right? What kind of coercion would invalidate it? Many of these developing states that are now independent, right, they want a definition that includes economic coercion. Right? They fight for that. There's this famous 19-state amendment that doesn't actually get passed, but there's a kind of an agreement to disagree that's kind of codified there. There's also debates over what will become the Friendly Relations Declaration, which is meant to codify states' understanding of customary international law with regard to the UN Charter. And there, too, there's this debate of should there be some recognition here of economic coercion, either as a violation of the prohibition on use of force or a violation of non-intervention. They get some wording in there, too, that seems to perhaps suggest that maybe that's included there, right? That's seen as sort of a victory because it does encode economic coercion, at least within the preamble. But what you see in kind of the story I tell is that while this is a very live debate through the 60s, right, by the time you get to the 1980s, right, the developing states have lost. Right? So throughout this period, the developed states are pushing back. They're saying no. Right? Coercion under all of these rules is just military coercion. Right? It's the use of armed force. Right? We can't have a system that's based that prohibits economic coercion because then all relations are potentially invalid. Right? There's always going to be a stronger party and a weaker party. Right? We should narrowly interpret force and coercion to be armed force. By the 1980s, right, they seem to have won. Right? It seems like the system has basically congealed around kind of the power of the northern developed states. And when you look across kind of both the rules that develop and sort of scholarship on this, the consensus seems to be, right, you get this line from the Nicaragua decision that there is no freestanding prohibition on the use of economic force in international law. Right? So that seems to be where things are, and developed states have won. But now you get to today, right, things seem to be shifting. Right? All of these developed states are now the ones saying economic security is national security. Right? They're the ones who are worried about economic force and economic measures. And you get the epitome of this in the European anti-coercion instrument. So this is an instrument that was adopted by the European Union, so it was inspired by the first Trump administration. It was drafted with China in mind. It will probably now be first used with regard to the second Trump administration. But the idea of the anti-coercion instrument is to recognize that some economic measures can be coercive enough to violate international law's prohibition on non-intervention, and then to authorize the use of some kind of response. There is irony here, right? Because they're basically embracing, and they actually reference the Friendly Relations Declaration in doing so, the exact same understanding of coercion that they were long accused of using against these developing states.
So, you mentioned the EU anti-coercion instrument, and I'm curious if there's one factor that you can kind of attribute this changing definition of security among developing countries to, or if there's kind of a barrage of factors that create this kind of change in mentality in international law. So I guess a few of the commonly cited ones are kind of a fall of what is called the liberal or rules-based international order. Another one would just be, the rise of China, on its own, and another one might even be the return of the second Trump administration and kind of a view towards protectionism in the EU, thinking that it needs to protect itself not only against what it viewed as an adversarial power, but now the U.S., which has been the Union's closest ally for decades. So is there a specific factor in mind that you think kind of creates this changing international order and the changing definition of security?
So the single factor would be anxiety. But so just to come back, I think there's two things going on. So one, I hope that the story that I'm telling points out the fact that the definitions we had before weren't conceptual, they were contingent. Right? So to the extent to which we had some understanding of what counted as security and what counted as economic before, that was merely contingent on who had power at a particular time and what made them feel insecure. So I'd say the order we had before, right, the powerful states, right, when they looked out at the world, what made them feel insecure, what made them anxious, it was mostly military force. It was things potentially like terrorism. Eventually maybe it was things like drug trafficking, but right, those are the things that made them feel insecure. It was not kind of the economic insecurity that much of the rest of the world felt. What's happening now is that a combination of multipolarity, right, so the rise of not just China, but many countries have become much wealthier than they were before. They are now able to have their own policies in different kinds of ways than they could before. The rise of different kinds of wealth, so here we think about technological developments that might change who might have power in this system. The advent of the emergence of new threats like climate change, right? All of that has states that once thought they understood their security risks, rethinking what their security risks really are, right? So they're anxious now, and they're anxious about things that they didn't think they were anxious about before. And so now, with this anxiety, they're looking out and saying, okay, we need to rethink these definitions because they don't fully capture what we need in order to feel secure. So I think that is the fundamental thing shifting all of this, right? The sense of anxiety about what the rules are and whether or not the particular interpretations actually work for them. And that's kind of creating all the flux we're seeing. So I say things like a fall of the rules-based order or the liberal order, right? Those are actually manifestations of this, not the cause.
Right. I think it's interesting, one thing you talk about is kind of the push and pull of how to actually define the name of the order and how the actual title of what different countries call it is in some ways powerful because it helps shape the playing field by which you can operate. So, the U.S. has kind of alternated between calling it rules-based or liberal international order. China, by contrast, has called it the international law-based order. So how does that, as you argue, shape the boundaries of how international law operates?
Yeah, so this should be a little mysterious to international lawyers, right? There's a lot of fight about how to describe the order, how to characterize it, right? Everyone's fighting, is it a liberal international order, is it a rules-based order, is it an international order based in international law? Why? Right? What difference would it make? And I think that seeing the international order as an interpretive mechanism helps to explain why these fights are actually meaningful to those who are engaged in them. Right? What they're essentially doing is trying to work the rest. Right? So to the extent to which the order is going to decide how you characterize that order is going to put a thumb on the scale in terms of certain interpretations or others. right? So a liberal international order might suggest, and this is how people have often read the US or Europe in saying this, it might be read to promote certain either rules, right, say human rights, over other international rules, say sovereignty, or certain kinds of norms, maybe ones based on democracy, over other kinds of norms and interpreting particular rules. So if you have to figure out sort of the shape of sort of sovereignty under international law, right, we're going to use kind of this liberal international order as a way to say, okay, these interpretations are more likely to be right than those. A rules-based order seems somehow different. It seems to be suggesting that it's not necessarily just the kind of the law that's out there, but in some sense, it's something else. Either it's more than that. Right? So some states have looked at what the U.S. is doing and calling for a rules-based order and saying, we see what you're doing. You want to include all of these soft law norms that aren't law and say that those are actually the key things in the order, because that would otherwise we'd say it's an international law-based order. Or they want to word spicy saying, you're saying that there's lots of law that we don't have to care about. What we need to really care about are some kind of rules to this order, perhaps certain procedural norms about multilateralism. On the flip side of this, right, China has emphasized either an international law-based order or an order built on international law, and it seems like what they're trying to do there is emphasize these rules or norms that are more based around state sovereignty to say when we have a conflict between these two different interpretations, we should lean into recognizing the sanctity of the sovereign state and its ability to do things for itself. So these are real, to in a sense, all of these arguments are attempts to kind of tell those people, really us, right, who are making these decisions about which interpretations are right or wrong, what rules they should be using in deciding one way or the other. And in a time of flux, right, these debates become particularly heightened because they're basically trying to kind of put a particular norm on the table before things really solidify, right? You're hoping that however these institutions will end up solidifying, they're going to solidify around your conception, right, of what these rules should actually be.
Well, it's a fascinating article. We're really looking forward to publishing it in MJIL. I want to transition just to some more fun questions at the end here. So, if you could recommend one piece of media on international law, a book, article, could be even a movie or TV show for our audience, what would it be and why?
So it's funny, had you asked this before writing this paper, I would have said read Robert Cover. Because I think that's now out there. I think
we'll do that as well.
We'll all read Robert Cover. I often come back, so I think that for thinking about international law and trying to think about international theory, it is very valuable to get outside of the four corners of the law. I think it's really good to go to things like fiction and particularly science fiction to kind of broaden our thinking, like to think about how could things be different. But I often go back to kind of a very classic piece of fiction, which is Rashomon. So this is an Akira Kurosawa movie. I don't know if people may know it, but you should go and see it if you haven't. So this is a classic Japanese samurai movie by Akira Kurosawa. I think it might have won Best Foreign Film, maybe even Best Film at the Oscars. Basically, the setup, if you don't know it, right, is that you're in kind of medieval Japan. There is a husband and wife going through the forest. They're attacked. There's a bandit. The husband dies. And now the whole movie is taking place before the magistrate trying to find out what happened. And rather than being told what happened, you see kind of what happened through the eyes of the wife, through the eyes of the murdered husband, through a medium, through the eyes of the bandit, and then eventually through a woodcutter who had been coming by. And the great thing about the movie is that this is actually a misconception people have. The movie does not resolve, right, what actually happened, right? You have to kind of make sense of all of these different stories. And I think it really captures kind of the way in which we actually interact with law, right? We don't get just kind of this is the rule, right? We have to kind of talk to each other and work things out, and kind of through these community interactions and through a sense of pluralism, kind of develop some sense of how we're going to keep going on. But
I was not familiar with that. I'm going to have to check it out. So thank you for the recommendation. So final question: what would be your advice for a law student who wants to publish a sharp, original work of legal scholarship? And this question is not just for me, but also for anyone who might be watching.
Yeah, so I mean, there's the easy answer and the hard answer. The hard answer is better, right? So the easy answer is to find some question that's obviously out there right now that people are kind of concerned about, that has a reasonable amount written on it, but not too much where you think you might be able to find some kind of space. But that's not the good answer. The good answer is you need to find something that you're passionate about, right? So you need to find a question out there that's bothering you, right? Something you want to know the answer to, something that you want to live with working through, right? And when you find that question, you then have to think, okay, what can I bring to bear to this question, right? Because there are going to be things that you can't do, right? Some people will have the ability to bring empirical tools to a particular question, other people won't. Some might be able to bring historical tools, right? Some might be able to bring more jurisprudential tools, right? But you should be thinking, okay, what can I bring to this question? And then you try to work it out for yourself. And if you work it out for yourself in a way that you feel somewhat satisfied by, but you should never feel totally satisfied by, because then you probably got it wrong. But if you feel like you're reasonably satisfied with the way you've answered it, then I think you probably have really good, sharp, interesting scholarship.
Professor Harlan Cohen, thank you very much for your time, and we'll look forward to reading your article.
Thank you.